consider the best way to do that would be to have the accused persons in remand, especially for the 3 serving police officers, as they entertain the matter. That does not take any away of their rights. The fact that they will be in remand does not in any way indicate that they are guilty of the offenses. They will still it. But I think this needs to come out very clearly. The accused persons have all the powers.
Kindly, counsel, let's not veer off.
Yes, my lady.
We are on criminal case E074 of 2022.
Yes,
The
that
last
is where we
sentence
are.
you are veering off.
That is where we are.
The rest is okay. It relates to this case. The last sentence,
Allow me to conclude, my lady.
you are addressing a different issue.
Allow me to conclude.
Yes.
Contrary to what Mr. Muganda was saying, that the object of bail and bond is to compel attendance, our position is that this court should have a broad outlook of the circumstances, the unique circumstances of this case. And render a ruling that will not only be fair to the accused persons, but most importantly, and even bigger than all of us, preserve the integrity of this trial process.
I associate myself with the sentiments of Mr. Abdikadir and Mr. Willis Otieno. I will bring you.
Who is speaking? Who is speaking now?
Mbanya. Mbanya.
Yes, continue, Mr. Mbanya.
Yes, I will bring your attention, your ladyship, to the general principles enunciated in the bail and bond policy. In particular,
Bring that bail and bond guideline 2015. It's right there. Can you see it? There. Kenyon, turn that side there. Yeah, go on. I want you said you are bringing it to the court's attention,
yes,
so I want
yes,
to look at it.
Yes.
As
In particular, paragraph 3.1 D, titled "The Right to Reasonable Bail and Bond Terms."
Paragraph
3.1 D, that bond conditions should be appropriate to the offense committed and take account the personal circumstance of the accused persons. So it should be appropriate to the offense committed and take account of the personal circumstance of the accused persons. Your ladyship, the offense that the accused persons are charged with, as you've been told by my colleagues, I would be more particular, is that 1 is murder, 2 is rape, and 3 is torture as a crime against humanity. These are very serious offenses, as was submitted by Mr. Otieno. The personal circumstance of the accused persons that we are asking the court to consider is that the accused persons are not only police officers, but the first accused person is an OCS currently. The third accused person is a chief inspector.
first accused person is OCS of where? If you don't know, it's okay.
Third accused person is a chief inspector.
Okay.
And the fourth accused person is also a chief inspector. Another circumstance I want to take you on, second accused person is currently on terminal leave and has also been stated to have actually, I will bring your attention to paragraph F, 3.1 F, and the policy requires
It's okay. It's all right. He's reading it out.
to consider the safety of victims and victims' family in fixing the amount of bail. In your ruling, which I have quoted in support of our opposition to the bill, to the accused persons, I will allow my colleague, Mr. Mango, to proceed, Your Ladyship.
Your Ladyship, I would begin from just rehashing the provisions of Article 49(1)H of the Constitution of Kenya, which guarantees the right of an accused person to be released on bail. However, Your Ladyship, the said provision of the law has a condition precedent, which includes there being in existence of compelling reasons why an accused person ought not to be admitted to bail. Your Ladyship, on our previous argument, I asked you to consider the decision of the Court in the Republic versus Jackson Malende and 3 others, which stated paragraph 80, Justice Lesit, as she was then, submitted that on the question on the right of presumptions of innocence until proven guilty, the mere fact that an accused person is denied bail does not mean that he stands convicted. And now that she is out of active employment, that immediately makes the second accused a flight risk. This is in contradiction of the finding of the bail report as the second accused being a flight risk. My lady, finally, based on the nature of the offenses, and I emphasize, which I have read out, the relevant provisions of the law, I invite the court to decline the invitation that the court maintains the previously set bail and bond terms. That would be all, lady, unless the court has any question.
Or comment? Anyone else?
Your Lordship, my name is Munoko for the first accused person. Your Lordship, given that the prosecutor and the investigator are not opposed to the release of the accused person or retention of the bond terms that have been existing, also agree with the report and have no objection to the report that has been filed and submitted by the probation officer. Your Lordship, which report has taken care of the sentiments of the victims and the accused persons, and the case from the time it started in 2022. Your Lordship, I'll invite this court specifically to page 5 of the report on John Masha, where the probation officer has categorically stated that he reached out to the victims. Some of them could not be found. Some of them even are not aware of this case. Some of them, they want nothing to do with this case. Your Lordship, in that report, I'll also refer you to page 11 on safety and security of victims. The probation officer has concluded that there have been no threats to victims or anything concerning their safety, and that there has been no complaints to any authority that will warrant. The counsels for victims will want to rewrite and become probation officers in this court.
And so?
I retract.
Yes. Go on.
Your Lordship,
That bit, we leave it.
we leave it, Your Lordship.
Yes.
Your Lordship, this report returns a positive report about the first accused person. And Your Lordship, it says that there is no sworn affidavit from IPOA objecting. Your Lordship, the first accused has been on personal bond from October 2022. There is no complaint that he has committed any crime during that period. Your Lordship, the records can bear him witness. Nothing shows that he has ever absconded his court. He has religiously been attending this court wherever and whenever he's been required. Your Lordship, if at all this court has to vary the bond terms that have been in existence, there should be something new that is presented before this court to prove that upon taking plea, the accused person, his character has changed or he's become a threat. This court was gracious enough that even after taking plea on 5th of May, retained the same bond terms. Up to this afternoon, the accused person is present before this court in honor of the bond terms. you've been told that the accused person, the first accused person, is a commander. I wish to refer you to paragraph 57 of Justice Kimondo's ruling of 25th July 2024, where he said that as to whether the accused person is a commander or not is a matter to be determined by this trial court. Your Lordship, I request that the issue of command should not be brought here to deny them bail or to enhance bail terms, Your Lordship. Your Lordship, this court has a duty to protect the interests of the victims, but more so it has a duty to protect the constitutional rights of the first accused and all the accused persons, Your Lordship. That one is equally replicated in Article 64 of the Rome Statute. Your Lordship, when you are told that the first accused will influence the outcome or will influence something to do with this case, in essence, that means that the first accused, the victims are saying that even the first accused will influence you. The first accused maintains that he has a lot of respect for this court and he hopes to come so that justice can be done to him. He will not influence anything. Were he in any influential position, Your Lordship, he could not have taken plea. And because he is vulnerable, he has no godfather. That is why he is taken plea.
Again, we leave out godfathers.
Thank you, Your Lordship.
Yes. Mm-hmm.
And that is why, Your Lordship, he is here and he has taken plea. So, and it is in his interest, Your Lordship, to ensure that this matter is heard as fast as possible and concluded so that he can be vindicated. He wields no powers and he has no privileges, Your Lordship. Your Lordship, finally, I wish to also request that you've been told that they should present sureties in this court. Your Lordship, what justifies even sureties on their own personal bonds? They have been present in this court. Your Lordship, in granting bond and cash bail, you remain the last person. And this report has concluded that they have no objection to the grant of bond, Your Lordship. I request that, Your Lordship, you be guided by discretion to grant and retain the bond terms that the accused persons have been enjoying. At any point, if they act contrary to the terms, nothing prevents this court from revising the terms and even sending them to custody, pending the hearing and determination of this case. I also invite you, Your Lordship, to look at paragraph 50 of the Court of Appeal ruling in Court of Appeal case number E092 of 2024, which is in the court file, where the Court of Appeal, 3-judge bench, Court of Appeal stated that the issue of command responsibility is a serious issue and the accused person should have their day in court for that matter to be determined, Your Lordship. And this is a new matter in the jurisprudence of this country, Your Lordship. I so request that, Your Lordship, you retain the bond terms.
On command responsibility. Your Ladyship, both the court and all the parties here to acknowledge the novel nature of such a principle of criminal law or the trial of criminal matters locally within our jurisdiction. Indeed, it is an importation of the International Crimes Act, which has not gained any footing locally. Your Ladyship, my lady, for the principle to correctly apply in the matter at hand, and for any party to have or to be allowed to have make the suggestion that the accused person could under any circumstances be found guilty under the command responsibility, then that will only happen once the Court of Appeal will have rendered itself in the pending appeal being registration number E124 of 2024. The Ladyship has been addressed on a finding by the Court of Appeal concerning the question of the command responsibility. Therein, the court rightly determined that that is a triable issue. In fact, the only issue pending for trial before the Court of Appeal. It is therefore not right and indeed very unfair to the accused persons for claims or allegations to be made on the accused persons for having been secondarily responsible to the alleged of the commission of the alleged offenses, so as to found the basis of denial of bail to the accused persons or the imposition of stricter, more restrictive terms to any bail that the court may wish to admit the accused persons to. As the Court of Appeal has rightly found, Your Ladyship, the accused persons deserve their right of their day in court, and that is in the advancement of the unabrogable right to fair hearing, Your Ladyship. This court, Justice Kanyi Kimondo sitting, has found in a past ruling that the principle of command responsibility, under which the court is being asked to deny the accused person's bail, it's a matter for trial, Your Ladyship. At this point, we cannot be sure whether the charges leveled against accused persons would be admitted for trial if the obtaining laws, substantive and procedural, were to be strictly applied, Your Ladyship. We urge the court to ignore submissions by the victims seeking to draw culpability upon the accused persons merely on the basis of the purported or the alleged command responsibility, Your Ladyship. Already, submissions have also been made by victims' councils seeking to impose blanket condemnation upon the accused persons in circumstances where an officer, an authorized officer of the court, has tabled before the court individual or independent reports concerning both work, social, and other status of the accused persons. Already, the reports have no correlation with one another. They independently mention the accused persons. My lady, of interest to my submissions is the report concerning the third accused persons. And I invite the court to consider page 8, the second paragraph thereof.
Which reports are we referring to?
The report,
because I may not seem to have it.
The probation and aftercare service bail report
Oh,
concerning.
the bail report
Yes,
of the.
that is the only
Okay.
report the defense have. I wonder whether there is, in the answer of the court, any other report other than that.
May I just state clearly that I also have submissions of 10th June, and I have been served with a case of 57 of 2016. So now you know what I have. So you're referring to the bail report of the third accused, eh?
Yes, my lady, the one relevant to Cyprian Robu and Kio. My lady, even as I make that reference, now that the court has introduced the issue of matters or documents that are before the court, but which we will confirm to the court were not served on us. And that is contrary to the last directions given by the court on the need to file responses to the bail or probation report together with any submissions which were thereafter to be served upon the defense. For our input. The ladyship, we do not understand why only the court has the advantage of such service, while the defense representing the accused persons.
Mr. Miari,
Yes, my lady.
we can blame the court for everything,
My lady, we are not blaming
but
the court.
not for what has been filed, especially
Yes, my lady.
when you follow up and say that the court actually gave orders.
Yes, my lady.
You file and serve.
My lady.
So how can you wonder why it is only the court that has? My duty when I'm proceeding online is to tell parties what it is that I have.
Yes, my lady.
And that I have discharged. So these ones
Yes, my lady.
just exonerate the court. Blame the court for everything else.
My lady, my submissions are
But
not.
this one, yes.
My submissions are not to blame the court, but to put it on record that so far there is a violation of the directions given by the court. Ladyship, I believe it has gone on record that
It hasn't. It hasn't, because when we started off this morning, I actually indicated what it is that I had, and none of you said anything. So I safely assumed that you are all aware that the fourth accused person has filed submissions, all right? And then, as I have been asking, who else? Who is the next person to address the court? One of your colleagues ably addressed the court and indicated that they are referring this court to criminal case number 57 of 2016. And I think this one we can all get it on EKLR, the case of Leleman.
of accused persons on some purported joint report. When the report starts singularly on the accused persons, Your Lordship, and I was drawing the court's attention to the peculiar special circumstances of the third accused person I represent before court today. I have made reference to the material paragraph of the report referring to those instances suggesting that the third accused person was not present at the time the offences are alleged to have been committed. Your Ladyship, it would not be fair, therefore, to deny such an accused person then when an officer of the court is almost vindicating the accused person of the commission of the offences, or to limit or restrict the conditions or circumstances under which such bail should be administered in the exercise of the court's discretion, Your Ladyship. My Lady, the circumstances already imposed by the court previously for bail to the accused person so far, attendant to the personal recognizance given to the accused persons, are already quite limiting and restrictive enough, Your Ladyship, so that the imposition of further terms as seemed to be suggested by the victims in their submissions would now lead to a total violation of some of the fundamental freedoms requisite for the accused persons to mount a defense to the charges against them under, I believe, Article 50. And Article 50, fair trial. And some of those freedoms, Your Ladyship, include the right to free movement within the country, Your Ladyship. Lady, the court's attention has been drawn to segments of the report touching on the third accused person, mentioning her matrimonial origins to be in Kisumu. The Ladyship, while the fact of that matrimonial statement is correct, that she hails from Kisumu, the Ladyship, the report does not go further in clear details to mention that there are two Nyaland Mamboleos. There are two Mamboleo areas not clearly mentioned in that report. The third accused person hails from the rural Mamboleo area and not the urban Mamboleo area within Nyalenda, which was mentioned in the earlier terms imposed by the court on the movement of the accused persons as a condition for the granting of bail, Your Ladyship. Lady, may I mention that all of us, as parties to these criminal proceedings, we will not have our cake and eat it at the same time. The Ladyship, we are either trying the offences brought before the court under our municipal laws, both procedural and substantive, or we are adopting the Rome Statute domesticated through the International Crimes Act. The Ladyship, on that, I wish to disabuse the notion that these proceedings are so special so as to make the court want to curtail the liberties of the accused persons as submitted by counsels.
I'm not waiting. I hope you're noticing.
Yes, Your Ladyship. Lady,
you have submitted that the issue of command is one of the triable issues.
My lady, I will address about 2 to 3 issues. The first one is the issue that the investigating officer, IPOA, addressed you on. My lady, I'll address you on about 2 to 3 issues. I'll start with the one the investigating officer addressed to us on. That is in regard to deposit of travel documents. My lady, before any police officer travels out of jurisdiction, my lady, it's a requirement that they get travel clearance, indicating the reason for which travel is sought. And that, my lady, that includes how they intend to take care of themselves when they are outside the country. My lady, I thought that is important for us to have that behind on record, because it adds another layer of security. And the fact that the Office of the Inspector General has a way of ensuring that the officers who are accused here present themselves in court when they are so required. In terms of the proximity of the officers and the alleged victim,